Hello. Good morning, everybody. Welcome to today's edition of the live employment law Q&A by employmentlawyer.ca. My name is Teilen Celentano. I'm an associate employment lawyer with Samfiru Tumarkin LLP based out of our Toronto office. If you have any questions today, feel free to post them right now, whether through Facebook, LinkedIn, Twitter, X, YouTube, and I'll answer them live. You can also submit questions through employmentlawyer.ca, by email at help@employmentlawyer.ca, or you can give us a call at 1-855-821-5900. I'd like to start today by talking about the Suncor's acquisition of Total Energy's Canadian operations. The transaction is for upwards of $1.5 billion. Whenever two large companies merge or one purchases one another, like in this case, there are a ton of things employees need to look out for from a legal perspective. As with transition, with change, with mergers, there is a ton of change and a ton of legal issues that may arise. First and foremost, oftentimes positions are made redundant. Oftentimes happens in places like the billing department or the HR department, where there just isn't a need for twice as many people. Therefore, people are laid off and let go. Oftentimes, those employees are then offered a severance package that is not equal to their full entitlements under the law. So if you're an employee who's laid off as a result of an acquisition or a merger, it's important to contact an employment lawyer like myself, who'll be able to review the offer and let you know how it fits in relation to your entitlements at law. Additionally, companies will sometimes impose new changes to either your duties or your hours. For example, you may have worked for one company on day shifts for 15, 20 years, but upon the change, you've now been switched to night shifts. Changes like that are substantial and can result in a constructive dismissal of your employment, thereby entitle you to severance. As I've said, and as we've said before, a full severance package can be as much as 24 months. So if through the transition period, there are changes made to your employment, once again, contact us at employmentlawyer.ca, and we'll be able to take a look to see whether or not you're entitled to severance as a result of that change. The last thing to look out for are changes to contracts. Oftentimes, during these transitions, the new employer sees it as an opportunity to update and limit an employee's entitlements under law. Generally speaking, if there's no employment contract, you're entitled to up to 24 months severance, depending on age and length of service, as well as a number of other factors. But a well-written employment contract can limit you to your entitlements under the applicable employment standards legislation in Ontario, the Ontario Employment Standards Act. Under that legislation, your termination entitlements can be capped at 8 weeks termination pay and 26 weeks severance pay for a total of 36 weeks, far less than the 24 months or 104 weeks you could otherwise be entitled to. So if through a transition you're asked to sign a new contract, again, have an employment lawyer with Samfiru Tumarkin review it so we can tell you exactly what you're signing away in exchange for continued employment. Scott from Facebook asks, how can a company offer to pay only terminated employees by virtue of signing a waiver or giving up their rights to further legal action? So that's kind of a two-part answer. First, your entitlements under the ESA, under the Employment Standards Act, are not subject to a release. So if a company is attempting to have you sign a release, in which you forgo your right to pursue further legal action, that is unlawful. However, if a company is offering you a severance package that includes amounts over and above of your entitlements under the Employment Standards Act, then they are allowed to ask you to sign a release. It is always up to you as to whether or not you would like to sign a release. Releases are common, almost invariably part of settlement packages we negotiate on behalf of our clients. However, what they mean and the implications of them are oftentimes difficult to understand to the untrained eye. So if you're offered a severance package and asked to execute a release, before doing so, contact us at employmentlawyer.ca so we can help let you know what you're entitled to. Matea says that she appreciates the live videos and the stash, so thank you very much. It's always good to hear that. Ashby says, my partner's employer just let him go due to lack of availability. Then later followed up to say it was for cause and listed a number of reasons. Can they change the reasons like that? Well, actually, it depends. So generally speaking, no. If they first lay an employee off without cause and then attempt to change their reason for termination to a just cause termination, it's difficult for them to win in court. It's not impossible, though. Oftentimes, that can happen if the company has after acquired cause. And what that means is they found things that they didn't know before, whether it was, through reviewing video evidence or things that thereafter came to their attention that had they known happened during your partner's employment, they would have relied on to establish cause. As is said on our website, and as I'm sure other people have said throughout the various editions of the live employment law show, cause in Ontario is incredibly hard to make out. Our courts have called just cause and terminated an employee without the payment of any severance entitlements. They consider it the capital punishment of employment law. Just like there needs to be a very high standard met for capital punishment, there needs to be a very high standard met for just cause. The exact implications of what it means in each case is different, but generally speaking, employers can't make it out. So if your partner has been let go for just cause, make sure they don't sign anything. Don't have them challenge it or try to negotiate with their employer. Reach out to us at employmentlawyer.ca. One of our experienced legal professionals will be able to help your partner out. Okay, so Tony on YouTube asks, can an employer fire you for a mistake that other employees have not been fired for? So the nature of the mistake obviously matters. Under the law and under the Employment Standards Act, an employer cannot fire somebody without the payment of any termination entitlements unless they have been guilty of willful misconduct or neglect of duty, which is not trivial or condoned by the employer. And right there, both the condoned and the trivial are the two important parts of that to answer your question. So if the mistake is small, you show up 5 minutes late to work, you drop and you knock something over and break something. If it's a genuine mistake, generally speaking, it won't be cause. And the second part is condoned. So if there's constant behavior that is condoned by management, showing up routinely, everyone routinely showing up 5 minutes late, a laissez-faire attitude towards submitting timesheets or, in my case, hourly dockets. If everybody does that, the employer does not discipline, does not raise it as an issue, then the court will deem that they've condoned that behavior, and they are prevented, they're stopped from relying on that same behavior to establish just cause for termination. It's also important to mention, though, that employers in Ontario do always have the right to terminate an employee for reasons not protected by applicable human rights legislation. So if you do something and it's a mistake that other employees have made and your employer decides to terminate you anyways, there's nothing we can do as employment lawyers to get your job back. All we can do is ensure that that termination is without cause and make sure you are given an appropriate severance package. It's difficult sometimes when that happens, but our employment lawyers at employmentlawyer.ca can ensure that you receive the severance package you're entitled to. Sam Lupin says, if you work for an American-based employer from Canada, are you entitled to take Canadian holidays? Well, Sam, fantastic time, and obviously given Thanksgiving weekend coming up, yes, you are entitled to take Canadian holidays. You're also entitled to vacation pay and public holiday pay in accordance with Canadian employment law. That said, it's oftentimes difficult to get. Employment law in Ontario and in Canada is much more friendly to the employee than employment law in the US. This is a fantastic example. Another great example is employment at will. In the US, generally, most states have the doctrine of employment at will, which states that an employee can be let go without any severance. Our courts have consistently and routinely said that doesn't exist here, and instead employees are entitled to severance packages worth up to 24 months. So if you have not received your vacation pay or vacation pay, public holiday pay, or time off for Canadian holidays, then I suggest reaching out to one of the lawyers at my firm with employmentlawyer.ca. We can help you reach out to your employer to make sure you get that. In the event that an employer refuses to, notwithstanding your request, you can also consider, with the help of one of our lawyers, initiating a Ministry of Labor complaint. The Ministry of Labor exists, and their complaint process exists outside of the formal court system and was created and it is used to enforce your rights under the Employment Standards Act. Things like public holiday pay, vacation pay, entitlement to bereavement leave are all things that are provided for by the Employment Standards Act. If an employer who's operating in Canada, and your employer is because they're employing you and you live in Canada, they have to follow those laws, and the Ministry of Labor will order them to enforce it. Moreover, the Employment Standards Act explicitly prohibits against reprisals. So reprisal is retaliation for you attempting to enforce your rights. One of the most common examples of reprisals we see, Sam, are people in your situation where they ask their employer, I haven't received my 4% vacation pay. I haven't received my time off for Canadian holidays. I haven't received my public holiday pay, which is equal to about 3.7% year over year. I want to make sure I get that, and I want my back pay for the past 2 years that I haven't received it. In response to that, the American employer decides to terminate the employee. That's clearly a reprisal, and the company's decision to do so not only constitutes another violation of the Employment Standards Act, in addition to whatever you were complaining about in the first place. So it's important to reach out to an employment lawyer before you ask the company for additional vacation pay or time off, because doing so can sometimes further complicate the relationship. Question from Michelle on Facebook. Can my employer make me work from home permanently? So the work from home process or working from home and the hybrid work model that everyone was kind of forced into as a result of COVID has really changed employment law quite generally. Of course, people had to work from home full time when COVID first hit, as it was the only way employers and companies were able to function. As time has gone back, candidly, most of the issues I've seen are the other way, that people want to continue working from home full time and cannot or don't want to, and their boss is making them go into the office. The short answer is it depends. So if you sign a contract that said, if you sign a contract during COVID or have worked from home for a long period of time, and your employer is now saying, Michelle, this is permanent, then yes, an employer can make you do that. However, if you have been working in office, at the store, at the warehouse, wherever, at a physical location that isn't your home, and now your employer is saying, we want you to work from home full time and you need to have a home office that's private, for example, then that change could be considered a substantial change. As I said earlier, any substantial change to the terms of your employment can be considered a constructive dismissal and thereby entitle you to severance. Of course, that change needs to be substantial, and what substantial means is a contextual analysis, meaning one of our lawyers would have to review the circumstances of your employment. But in short, no, an employer can't make you work from home if you've been working in office or on location for a considerable period of time. Sam says, thank you. Our employer often makes our vacation days and entitlements confusing for Canadian staff. So again, that makes sense. That's not uncommon. Again, the kind of the issue you brought up and issues similar to it are ones we often see when dealing with American companies. Wish you the best of luck. And, if you need any more help, again, one of our lawyers can help you out. Nick on Reddit asks, is an email saying I agreed upon a severance amount enough to confirm I've accepted the terms of a severance? I made a mistake saying I agreed in an email and still want to speak to a lawyer. I haven't officially signed anything. Generally speaking, no, but it's important that you flag your mistake and articulate that you wish to speak to a lawyer to your employer immediately. Until the release is signed, we as employment lawyers will generally still be able to help you out, but it does make it a tougher hill to climb. It's important that whenever you're given a contract, a release, a settlement document upon your termination, that you don't sign it, you don't agree to it, you don't say yes, you just leave, right? Don't be rude, don't be disrespectful, but don't do anything that could be construed as acceptance of that offer. So in your case, you accidentally sent an email saying you agreed upon the severance amount. Flag this mistake to your employer in writing. Say, I just realized I made a mistake. I do not accept it. I'm speaking with a lawyer. I'll get back to you in due course. And then reach out to us, employmentlawyer.ca, so we can review the package. Oftentimes, employers will make settlements or make first offers after termination that are worth 20, 30, and 40 cents on the dollar compared to not even your best day, but even a reasonable day in court. And you could be leaving significant money. So flag the issue, make sure your employer knows it was a mistake, that you didn't actually agree to the amount, and that you're speaking to a lawyer, and you or your lawyer will be in touch shortly. So DXS on YouTube asks, my employer offered me a job that I had to relocate for. The position now won't be available until the end of the year, and I am being asked to travel much further to continue to work. I've asked for the time accommodation or mileage compensation, and I'm being told it's not an option. What can I do? So this is another substantial change, and it's kind of been the theme of our show today, unintended. So when an employer asks you to relocate, that oftentimes can constitute constructive dismissal. That's because the terms of your employment are, whether written or not, that you will work at the company's location where you were hired and where they continue to work, or at a location that is reasonable nearby. In the GTA, the Greater Toronto Area, our courts have generally said that a 1 hour drive is not unreasonable to get to and from work. So, if your drive is changing from 10, 15, 20 minutes to 30, 40, 50 minutes, it's sometimes tough to make it a constructive dismissal, but not impossible. In your case, where you're asked to relocate entirely, right? So move towns, move cities, provinces, countries, in order to serve the employer, them asking you to do that is allowed. And the question itself is not in and of itself a constructive dismissal. But if they were to say, you have to do this, or we are letting you go, you have to do this, or we won't renew your contract, you have to do this, or we're going to demote you, all of those things would be a constructive dismissal, as they're unilaterally imposing a substantial change. Unfortunately, it sounds like you've already accepted it. And now that the extra travel time may or may not be some compensation you're entitled to. Generally speaking, in Ontario, employees are not entitled to travel or mileage for getting to and from work. So it depends. But given the facts at play, I think it's really important that you contact us to talk to one of our lawyers. Until we have the full picture, it's really impossible for us to have a firm answer and a strong understanding of what you'd be entitled to and what you could stand to gain from a potential lawsuit. Matea asks, what about fully remote, then 2 days a week, a 2-hour commute, and a 2-hour commute one way? So again, Matea, it depends on what the contract said. So it depends on when you started. So if you started pre-COVID and you're already making that 2-hour commute each way, now that COVID has ended and they're going back to a hybrid model, then it's likely that that won't be a constructive dismissal and you'll have to make the drive. Conversely, if you signed a contract that was supposed to be for fully remote work, and now they're making you go into the office 2 days a week rather than 0. They're making you accrue 4 hours on the road each day. Well, then that's potentially a constructive dismissal. Again, similar to my answer to DXS, it depends. It depends on the facts of your case and the circumstances of your employment. Not only to ascertain whether or not the change itself would amount to a constructive dismissal, but also how much severance you'd be entitled to. As I have said, it can be as much as 24 months. The range varies. Our courts say that assisting severance is an art and not a science. And they look at a number of factors, including age, length of service, and availability of similar employment. So not every constructive dismissal makes sense to pursue for various reasons. So definitely reach out to us. Mateo says during COVID start, an official start office closed during COVID. So if you started during COVID, it would again depend on what the contract says, right? So the contract says it's a full-time work from home position and you'll forever work from home. Well, then they're changing of that to go to a two day a week in office hybrid plan is likely a constructive dismissal. On the flip side of that, if their contract said we reserve the right to require you to come in office full time or pursuant to a hybrid model, then the change wouldn't be a constructive dismissal. So again, like most things with the law, the answer is it depends. And reach out to us employmentlawyer.ca, and one of our legal reps will be able to let you know what you're entitled to. One thing to note, though, is when these substantial changes are imposed, right? So an employer says, come in 2 days a week, you only have a limited time available to actually trigger a constructive dismissal. Our courts have said that changes that are accepted by the employee, right? And changes that are accepted by the employee can then not subsequently be grounds for a constructive dismissal, meaning if the company had said, Mateo, to you, you have to start coming in 2 days a week, you do that for a few months, and then 3-4 months later, you reach out to us, we and attempt to start constructive dismissal suit, is likely that a court would say that change, so switching from a full-time work from home to a hybrid model, was condoned. And given that it was condoned, you can't now rely on it to establish constructive dismissal. That premise of condemnation is somewhat similar to the one I mentioned earlier with respect to just cause. Just like an employer can't terminate you for misconduct that they condone, it's difficult for an employee to make out a constructive dismissal on the basis of a change that they've condoned. Only got a couple more questions here, and then we're going to wrap things up. Sammy on YouTube asks, what happens if I give 2 weeks notice and terminated the same day? Am I owed any severance at all? So it depends on the timing of things, right? So if you intend to submit your resignation and then that morning you get let go before you can do that, you're entitled to a full severance package, right? You're entitled to whatever you would have otherwise been entitled to under the law. Conversely, if you walk into your supervisor's office and say, hey, here's my 2 weeks notice, I'm taking off, and they say, you know what, don't come in anymore, well, then you're only entitled to pay for those 2 weeks, right? You gave 2 weeks notice, they're entitled to pay you for those 2 weeks, to make you whole for those 2 weeks. They don't have any obligations after that. So the way, it's spoken about, in cases is that the company has the right to waive waive the remainder of your notice of resignation period, but they have to pay you for it. So while it would be a termination, because it occurred after your notice of resignation, they'd only have to pay you till the end of that resignation period. Okay, PKM Motorsports. Last question before we're all set here. My new employer of 4 months received an anonymous letter saying I was fired from my previous job for criminal activity. Absolutely not true. I was subsequently fired because I was not suitable. So this is obviously a hairy situation, right? Whoever sent the letter may have breached the law in and of itself, whether it's defamation. That said, that's absolutely not cause to fire you. But as I said earlier, employers in Ontario retain the right to let employees go for reasons that are not protected by the Employment Standards Act. So it's unfortunate that this happened, and you may actually have a case against the person who sent the letter. But in terms of a case against your employer itself, you'd likely only be limited to whatever you would otherwise be entitlement in the event of a without cause termination. So you, depending on how long you worked there, by the sounds of things, only 4 months, you would be entitled to severance on that basis, but you wouldn't be entitled to any additional damages for them receiving this anonymous letter. The only thing that, in this case, it's criminal activity. If your employer decides or attempts to let you go for reasons protected by human rights legislation, so age, sex, gender identity, gender expression, place of origin, etc. If you're let go for one of those reasons, even if it's without cause, that's also illegal. So in those situations, we can also help you get not only a severance package, but in some instances, additional amounts for the breach of your rights under the human rights legislation. Okay, so those are the questions for today. Just as we're wrapping up, if you have any more questions and that you want answered, feel free to reach out to us at employmentlawyer.ca so we can answer them at a next Employment Live show. You can also take them by email at help@employmentlawyer.ca, or you can give us a call at 1-855-821-5900. On our website, we also have a tool called the Severance Pay Calculator. So what the Severance Pay Calculator does is calculates how much severance you could be entitled to in the event that you are terminated. So as I mentioned earlier, there are a plethora of factors the courts can consider. Most frequently and most often considered age, length of service, availability of similar employment. So you plug in those factors as well as a number of others, and our severance pay calculator provides you an estimate on how much severance you could receive in the event that you won a lawsuit. It's an excellent tool to help you ascertain what your rights are and to compare it to an offer that an employer has made when they let you go. So that tool is available at pocketemploymentlawyer.ca. Okay, so there's no more questions coming in today. So I guess that's everything, and we'll wrap up. So again, my name is Teilen Celentano. I'm an employment lawyer with Samfiru, Tumarkin, and an associate with the firm based in the Toronto office. If you have any more questions, feel free to email them to us at help@employmentlawyer.ca or submit them at employmentlawyer.ca. I'll be back in 2 weeks on Friday, but we'll absolutely have other employment shows between now and then that you'll be able to tune into and get the help you need. Thanks, everybody, and I hope you have a fantastic holiday weekend.